All right, let's jump into some pretty complex stuff today. Legal interpretivism.
Mhm.
It really gets to the heart of what law is,
Yeah.
and how it connects to morality. Really, the big questions philosophers love.
Yeah, for sure. Going way beyond memorizing laws and stuff. It's about like what gives laws their power? Does it come from institutions or something deeper?
And to help us figure this all out, we've got the Stanford Encyclopedia of Philosophy's entry on legal interpretivism. So imagine, you're back in your philosophy seminar arguing about the nature of law, right? Is it just what courts and legislatures say, or is morality, like, essential to it?
That's the core issue. Legal interpretivism is all about the grounds of law, which basically means what makes legal rights and obligations exist, what makes them true.
Okay, grounds of law. Could
Mhm.
you unpack that a bit for those of us who haven't spent years in philosophy departments?
Sure, it's about the source of legal authority. Like, imagine a judge deciding a contract law case. The traditional view, the orthodox view, is that the judge just looks at past cases, the written laws, to decide. Law is like a closed system, and it's valid because of these institutional sources.
So the judge is like applying a set of rules to the case, kind of like a mechanic.
Exactly. But interpretivism says, hold on, moral considerations aren't just an extra, they're woven into how we understand and use law.
So it's not just about what the law says, but also about the moral principles that shape how it's interpreted and used.
Right, like going back to the contract law example, an interpretivist would say the judge isn't just applying rules, they're also thinking about fairness, the impact on society.
It's like those debates about the spirit of the law versus the letter of the law, right?
That's a great way to put it. Interpretivism suggests the meaning of law isn't fixed. It changes with our moral understanding and the social context.
So we're not just talking about if laws are morally good or bad. It's about how our ideas about morality shapes the meaning of law itself.
Yeah, exactly. It's about how we decide what those institutional actions, like passing a law or a court ruling, mean for our rights and duties.
So how does this play out in the different types of legal interpretivism? The source talks about hybrid and pure
All
interpretivism.
right, and that difference is key. Let's start with hybrid interpretivism. Think of it like a two-step process. First, you have institutions like legislatures and courts making the basic legal rules. It's like the raw material of the law.
So that's the institutional basis. Where does morality fit in?
That's the second step. Morality is like a filter. It helps us interpret those raw legal rules, making sure they match up with our moral principles to prevent unjust results.
It's like you have a draft of a law and you're polishing it up, making sure it reflects our sense of justice and fairness.
Exactly. A classic example is Riggs v. Palmer. A grandson killed his grandfather to inherit his estate. The law was clear. Wills must be followed. But the court said, no way, he can't inherit. It would be morally wrong to let him profit from his crime.
So the court said, hey, the law as written leads to a morally unacceptable outcome, so we need to interpret it through the lens of moral principle.
Yeah, hybrid interpretivism recognizes both institutional actions and moral considerations in shaping law.
That makes sense. But I have a feeling pure interpretivism is even more philosophically challenging, right? What's the main difference?
You're right. Pure interpretivism, also called non-hybrid, takes a more radical position. It says there aren't two separate sources of law. Morality is the driving force from the very beginning.
Wow, so it's not even about combining institutions and morality. It's saying morality is the ultimate source of legal authority.
Exactly. Pure interpretivism argues that morality dictates how institutional actions become law in the first place.
I think I need an analogy here to get this.
Okay, picture a sculptor with a block of stone. The stone is the actions of institutions like passing laws, court rulings. Morality is the sculptor's chisel, shaping that raw material into something meaningful. That's the law.
Ah, okay. So it's not that institutional actions don't matter, but they only become law when shaped by morality.
You got it. It's a bolder claim, right? It really challenges how we think about law and institutions.
For sure. Which raises a question. If morality is so central to law, why even have institutions? Why not just let philosophers decide everything based on pure moral reasoning?
Yeah, that's where we get into how law actually works in the real world. Even for pure interpretivists, institutions matter, right? Law isn't just a philosophical idea. It has real power. It can force people to do things, shape how they behave.
All right, it's not just about good intentions or having a moral code. It's about those principles becoming actual rules with ways to enforce them.
Yeah, exactly. And that's where legality comes in. Legality means, in this context, the ways moral principles become part of institutions and their processes. It's about making a clear link between moral ideas and what legal institutions do.
So it's not enough to just say, this law is good because it's morally right. You have to be able to connect that to how the legal system actually works. Right.
Exactly. Think of it this way. A government official promises some policy change. Maybe they mean well, and the promise is even morally good. But does that automatically create a legal obligation?
I feel like there's a but coming.
You got it. Just a promise, even from a high-up official, isn't usually the same as law. There needs to be more, some formal process, some institutional action that makes that moral commitment into a legal obligation.
So it's like the difference between a politician making a campaign promise and a legislature actually passing a law. Both might be about morality, but only the law has that institutional authority behind it.
Perfect analogy. And it shows why institutions are so important, even for those philosophers who stress the moral basis of law. Institutions provide the structure, the procedures that help us go from abstract moral principles to actual legal rules that we can work with.
But doesn't this lead to more philosophical problems?
Uh,
Different people, even different philosophers, might have totally different ideas about what those moral principles should be.
Definitely. And that's where disagreement is central to legal interpretivism. Interpretivists know there will always be debates about the moral foundations of law.
So it's not about pretending everyone agrees on one set of moral principles.
Nope, not at all. It actually embraces those disagreements. It encourages us to have open and honest debates about the values that our legal system is based on.
That makes sense. But how do we keep those disagreements from becoming total chaos? How do we ground them in something more than just personal opinions?
That's where principled consistency comes in. It's about looking for patterns in what institutions do and figuring out what moral principles best explain those patterns.
We're like detectives, looking for clues in court decisions, laws passed, trying to figure out the underlying moral code.
Exactly. And sometimes that detective work leads to surprising findings. We might see that the law, in practice, doesn't match the ideals we thought it had. Or we might find new moral principles we hadn't even considered.
This brings us back to the idea that law has power, coercive power. If law is shaped by moral principles, but we also know people disagree about those principles, how do we make sure that power isn't misused?
That's a big question for legal philosophers, and it brings us back to legality. Legality is about making sure that using force is justified, that it's not random or based on the whims of whoever's in power.
So it's about having checks and balances within the legal system and through society, debating these things, to keep the law from becoming a tool to oppress people.
That's it. And this is where interpretivism gets really interesting. It's not just about finding the right moral principles. It's about how those principles become specific legal rules and how those rules are then used and enforced in a way that respects people's rights and tries to achieve justice.
I can see why philosophers find this so fascinating. It's about power, morality, the nature of society itself, huge questions.
Absolutely. And it's not just theoretical. It affects how we understand and interact with the legal system. Whether it's contract law, criminal justice, constitutional rights, these principles of legal interpretivism are always there in the background.
Okay, we've covered a lot. Grounds of law, the difference between hybrid and pure interpretivism, the idea of legality, and the role of disagreement and principled consistency. But how do we actually use these ideas in real cases? It still feels kind of abstract.
Great question, and it's something legal philosophers are still working on. Take a news story, for example. Say a company is accused of breaking environmental rules. The traditional approach might just focus on the law as it's written. Did the company technically follow the rules or not?
A very black and white analysis, right?
Exactly. But an interpretivist approach would go deeper. What was the purpose of these environmental regulations? What moral principles are involved, like protecting the environment or public health? Are there special circumstances that might mean we need to interpret the law differently in this case?
So it's about looking beyond just the technical wording of the law and considering the context, the purpose, the moral implications of the decision.
Yeah, that's it. And this is where it gets really challenging, because it means we have to engage in moral reasoning, make judgments about values that might conflict. There might be good arguments on both sides, and the right answer isn't always obvious.
This makes me wonder about the role of judges. Are they basically being asked to be Moral philosophers as well as legal experts?
That's a question that's been debated forever. Some say judges should just stick to the written law and leave moral judgments to the legislature. Others, especially interpretivists, say that moral reasoning is a part of judging, especially when the law isn't clear or has multiple interpretations.
So there's no easy answer. It seems like the relationship between law and morality is complicated and keeps changing.
For sure. And that's what makes it such a rich area of philosophy. It makes us think about justice, fairness, where legal authority comes from.
This whole discussion of principled consistency is really interesting. But it also makes me wonder, does this mean that every single thing the government does, every law, every court decision, creates a legal obligation? That seems like it could get out of control.
That's a really important point. Interpretivism doesn't say that every moral consequence of what the government does automatically becomes like a legal obligation. There has to be a specific link between what the institution does and the moral principle to make it what we call law, you know?
Okay, so how do we decide where that line is? What's the difference between moral consequences that have legal weight and those that don't?
Let's think back to that idea of legality again. Legality is about making sure we're not just using force because someone said so. It's about anchoring the law in moral principles that can justify using state power.
So the law is more than just the random desires of people in power.
Exactly. So when we're trying to figure out if a moral consequence of some government action is legally binding, we have to ask, does this action fit into the rules and procedures we already have? Does it show a consistent application of moral principles? And can we justify it as a legitimate use of state power?
Can you give me an example of how this works in real life?
Sure. Imagine a government official publicly says they're against gambling, expresses their own moral opposition to it. They might even tell people to stop gambling. Morally, they've taken a stand. But does that mean gambling is now legally prohibited?
I'm guessing no, but why not?
You're right, it doesn't, because that statement, even though it expresses a moral view, hasn't gone through the steps to become law. It's not in legislation, it hasn't been tested in court, there's no law enforcement mechanism for it.
So there's a difference between what someone personally believes, even if they're in a position of authority, and the actual system of laws that we have to follow.
Exactly. That difference is really important for understanding legal interpretivism. It's not about erasing the line between law and morality. It's about how those two areas overlap and influence each other.
It's like those debates about judicial activism versus judicial restraint. Can judges bring their own moral views into how they interpret the law, or should they just stick to what's written?
That's a great point. And it goes to the heart of legal interpretivism. Interpretivists say judges can't just ignore moral considerations. Even when it seems like they're applying the law objectively, they're still making judgments about what it means, the context, the intent behind it.
So even when judges say they're being neutral, their own moral framework is still influencing their decisions.
Yeah, exactly. And interpretivism is about being honest about that instead of pretending that legal interpretation is purely objective.
This brings us back to principled consistency. If we accept that moral judgments are part of interpreting law, how do we make sure those judgments are fair, consistent, and impartial?
That's the big question. And legal philosophers have been trying to answer it for ages. One way is to focus on precedent. By looking at similar cases from the past, we can see patterns of moral reasoning and try to apply those patterns consistently in new cases.
So we're looking for the moral logic that connects legal decisions, making sure similar cases are treated similarly.
Exactly. And here's where legality comes back in. It's not just about linking moral principles to actions by institutions. It's also about making sure those links are applied consistently, predictably, so people see the law as fair.
Well, our listeners' minds are probably full of new ideas after this deep dive into legal interpretivism. It really makes you think about what law is, where it comes from, how it connects to our values.
Definitely. And if there's one thing I hope people take away, it's that law isn't some fixed, unchanging thing. It's always evolving, shaped by moral principles and what society values.
So to wrap things up, I want to leave everyone with a thought. If morality is so tied to law, as legal interpretism argues, where do we draw the line? As individuals, as a society? Is every moral consequence of what institutions do a legal obligation? What happens when our own moral beliefs clash with the legal principles that govern us? These are questions legal philosophers continue to debate.
And by thinking about these questions, by really engaging with this idea of the relationship between law and morality, we can better understand this complicated system that shapes our lives.
And on that note, We'll leave you to think about those big questions. Thanks for joining us for this deep dive into legal interpretivism. Until next time, keep learning and keep asking those challenging questions.